I'm James Hazlewood, an attorney and member of Carpenter, Hazlewood, Delgado, and Bolin. I've been representing community associations since 1989. I'd like to spend a few minutes talking to you about minimizing the impact of bankruptcies on community associations. Now, there's no question that owners and former owners who file for bankruptcy protection have some impact on associations. That effect is intended. The federal government wants debtors to have a, quote, fresh start, close quote. That does not mean that they get a free ride, living in a home without paying forever. Typically, an individual or a couple files for Chapter 7 bankruptcy protection. The goal and result of these filings is to receive a discharge of the personal debt that accrued before the bankruptcy filing date. In other words, they will not owe the association personally for the assessments that accrued before the bankruptcy filing. Well, what do you do? Mainly, don't panic. If the owner intends to keep the home, in almost all cases, the association will retain its lien on the property. The lien under the CC&Rs and under the statute for planned community associations and for condominium associations. The lien needs to be paid if they're keeping the home. In addition, assessments that accrue after the bankruptcy filing become part of that same lien. They also need to be paid for another reason. Under bankruptcy laws, the owners remain personally liable for the assessments and charges that accrue after the bankruptcy filing date for as long as they still remain owners of the property, even if they move out of the home. The bottom line is don't give up on Chapter 7 bankruptcies. Contact your attorneys. You've probably heard about Chapter 13 bankruptcies as well. In most Chapter 13 bankruptcies, the debtors want to keep the property. In its simplest terms, the Chapter 13 allows debtors to file a plan by which they pay back the unpaid assessments over a term of 3 to 5 years. Generally, they need to pay assessment arrearages through that plan. However, Chapter 13 bankruptcies are relatively complicated. Again, contacting your attorney can help you deal with things such as proofs of claim, objecting to the plan, and motions to be filed in the bankruptcy court. We'd be happy to discuss any aspect of bankruptcy with you. You can give me a call, or we would be happy to come to a meeting. Thank you.